What are some of the terms that they're changing that is just earth-shatteringly better? Well, first of all, they're deleting the words parental rights out of custody law. They've deleted it over 150 times. So step number one, we're deleting parental rights from custody law. The idea that we have no parental rights and that courts have ultimate say is scarier than assuming parents have rights, okay?
Hey, welcome back, everybody. So I have a special guest with me here today, and she is going to be talking about some really important issues that we're facing specifically as Ohioans. Now, while this could be applicable across the nation, hopefully it's something that is picked up across the nation. It's really important that we pay attention to what's happening in our specific states, hold our legislators accountable, and keep up with what's going on and updated, because as we all know, they like to sneak a lot of things by us every chance they get. So I have Elizabeth joining me today. How are you doing, Elizabeth?
I'm doing awesome. I'm really excited to be here. Thanks for having me.
Wonderful. Absolutely. I'm happy to have you join me. And we're going to be talking about Senate Bill 174. Now, I don't have the down low on all that. That's Elizabeth. So we're also going to touch base on legislation reform in general and the wonderful things that we, the people, have going on in regards to ending qualified immunity, which would be a game changer for us to be able to hold the powers that be accountable when they break the law, which not sure why it's not set up for us to do that now, but here we are. So we're going to be some trendsetters here in Ohio, and we're going to kick some ass and create some change. So welcome. And I would love to hear more about what it is exactly that this Senate bill is, what it does and does not do, and why we should be concerned.
Sure. Well, let me go back a little bit and tell everyone my background a little bit. So I am an Ohio mom. I live just outside of Columbus, close to the Capitol. I went through family courts myself. I'm now remarried. My husband also went through the family courts. Our experiences were very different from one another. And just seeing what we both went through and then connecting with other families, it seems like a lot of people have the same story. I'm an advocate at heart. I have a child with disabilities, and I've always advocated for him since he was born. So when I started seeing the systemic problems, coming out of family courts, I couldn't sit around and do nothing, because I do care about families and children. And I couldn't believe what I was hearing and what I was seeing. So I decided to get involved legislatively, because the more I looked at the laws and how they're written, the more I realized all of the flaws that are there and why courts behave the way they do, and how, attorneys and guardian ad litem's and CPS workers, like how it is that they seem to get away with some of the things that are going on. So 5 years ago, I got involved trying to change things legislatively. And when I first started, there was a lot of momentum, because I think everybody recognizes, okay, this isn't working. There's a lot of disagreement on how we fix things. But right out of the gate, I was fighting just as me, and, I have a small team of advocates here in Columbus. We're fighting the judges themselves, the Ohio Judicial Conference, which is like the association of judges. They were created by the legislature decades ago. Their job is supposed to be advising legislators on the fiscal impact of pending legislation. So like, if this bill passes, here's the financial impact it's going to have on our courts. That's their job. That's what they were created to do. Today, they operate as a lobbying group, and they lobby our legislators on behalf of the judges. So that was who I started fighting right away when I started to try and reform our laws. I have co-authored legislation too, and I've connected with a lot of legislators. And then the other constant opponent has always been the Bar Association. And of course, They have their hands on every piece of pending legislation, not just court related. I mean, their hands are in absolutely everything. They have very powerful lobbyists. There's a lot of money exchanging, and they're very, very, very powerful. So it was a quick lesson really immediately of who has really the power at the State House. And as a citizen, it was very concerning for me to realize that really it's the judges and the attorneys that run everything. There is more legislators who are not attorneys than are, but the attorneys that are there essentially have all the power. And so I'm an incredibly stubborn person. So when I started seeing this, I just fought harder, and I'm still fighting harder. And it just seems like more and more powerful people in these organizations are kind of coming to the surface and sticking their necks out there. So I've seen a lot. Okay.
And when you shine that light, those roaches scatter.
Yeah, for sure. And there's a lot of behind the scenes. We all know, I'm sure, that there's a lot of politics in games that they play with one another, and they leverage power and they leverage favors from one another. So that wasn't a surprise to learn. But what was surprising was just how dismissive they are of the people, of regular people. I'm not a lobbyist. I'm just a mom. Right. And I've connected with a lot of families, and I represent a lot of families because I know their stories, and I'm close to Columbus. So I can go to the State House and meet with legislators, and I'm just the voice. Right. But there's a general disdain towards people like me. And, really quickly, they're like, oh, she's not an attorney. What does she know? And so they rely heavily on the attorneys, the bar, and the judges. And when you talk to a legislator about a piece of legislation, first thing they're going to say is, okay, this is great. This actually makes total sense. You're right. We've got to do something. Let me talk to my judge and see what they think. And then nothing happens. And
Judge didn't like that idea so much.
Right. And it's obvious that happens. They even will come back. Some of them will be honest with you and come back. My judge didn't like it. I just think I can't do it. Sorry. So we're hitting a lot of walls to try and change things legislatively. And the bills that I have co-authored are large. They were 200 pages. Okay. One of the main things in it would be establishing an equal presumption in custody disputes. And that is really scary to a lot of people. And so when the focus from opponents was on that, they painted me to like ODVN as like an enemy of victims of domestic violence, because how dare you presume parents are fit because there's so many dangerous parents. And I definitely see that argument. But what's unfortunate is the bill I co-authored, bills were so much more than that. And they really protected families, and they focused on holding courts accountable. And that's the message that I want to convey today, is when you try to hold courts accountable, we were wanting them to track outcomes of cases so we can actually see their work. See, they don't do that right now in Ohio. So it's their word versus us on what happens. And they're the experts. Okay. So legislators are listening to them because they're the experts. It doesn't matter how many horror stories we bring, because there's no data to show that this actually happens. So that was one of the things that we were asking in our legislation is let's track the outcomes.
No transparency within family court either.
Yes,
and they're able to hide behind confidentiality because it involves minors.
Right.
And so we can't say anything. And it's like, if there's anything that's the most important, should be to protect our children. And in order to do that, that should be the most transparency offered and available for a court system, you would think. And it's just not like that, because family court is one of their huge money makers.
Yeah. And the law is very vague. In my efforts, I have been trying to address the law in a way that actually not just holds courts accountable and makes them show us their work, essentially. You can't be an informed voter. Our judges are elected. You can't be an informed voter if we don't know how they're performing. Okay. There's no performance mechanisms for voters to even be informed. Side note. But also our laws are very flawed because we all know the words best interest of the child, right? And we all argue over, well, courts aren't doing what's in the best interest of the child. The courts will tell you, of course, we're doing what's in the best interest of the child. And so why is that? Why is it that with everything that we know and experience, they can confidently say we're acting in the best interest of the child, while the parents are on the other side saying you are not acting in the best interest of the child? Why is that? How is that? And the reason is because our laws are very vague. Best interest of the child is not even defined, okay? There is nothing in our law that says what is generally best for children. So it's very subjective and undefined, and it's up to the courts then, because they have the power now to decide what is in the best interest of the child, which means because it's not defined, there's no statutory guidance on what to do. They have to apply their own personal opinions and biases on how a child is raised. That is what the best interest of the child standard does, is it requires courts to apply their own personal judgment. That is a huge flaw.
Well, I mean, you see the same thing happening within the CPS system too. They're so vague. Again, obviously abuse is abuse, but the vast majority, I think it's like 60-70% of children who are removed, it's for neglect. And there's no real set standards or guidelines, again, with that either.
Right. And that's intentional. Okay. And so language really, really matters when it comes to law. And when it comes to executing the law, and the bar fights really, really hard, and the judges now too, to keep language very vague on purpose, because that increases their discretion, right? The more you define something, the more guardrails are in place for the courts. They don't want guardrails. They want discretion. They want the power to decide what they feel is best. That's what they want, because they truly, and I've been in so many interested parties meetings directly with judges from all over the state, and even the associative representatives of the DR Judges Association, the leaders, I guess. And they all truly believe they know what's best for children. Okay. But they're all different people. So even if they believe that, no two people are the same. That's why two judges looking at the exact same case have come to completely different conclusions. Why is that? It's because they're applying their own personal judgment. But that's what they want. They truly believe they know what's best for kids. Okay. So I have to lay that up, because now, so they've successfully blocked our citizen-led efforts for reform the past 4 years. 3 years ago, the Ohio Judicial Conference sent over to me a copy of a piece of legislation they wrote. And they said, hey, we're working on this bill. And they were telling legislators, hey, don't go with their bill, wait for our bill.
Oh,
and
it
worked. It worked. Okay. They successfully blocked our efforts for the last 4 years. And then in the fall, this past fall, 2 family law attorneys finally introduced their bill. They reintroduced it this General Assembly because, we just got a new General Assembly starting this year, and they reintroduced it. This time it's called Senate Bill 174. The background of 174 is, one, it was written by judges, DR judges specifically. It was championed and lobbied by those judges. The judge who was in charge, or it's her pet project, there's multiple judges, but the one who really owns this bill is Judge Denise McCauley. She was a sitting judge 2 years ago when it got finalized. She's also the mother of Senate President McCauley. So Senate President McCauley's mommy wrote a bill to counter our bill. Okay, they even went on public record in hearings against our bill. Judges went and testified against our bill and pitched their bill in the same oral testimony, public oral testimony. Okay, they are blatant and proud of the fact that, one, they're fighting us, and 2, they wrote a bill because, of course, they know what's best for us. So it's very problematic on so many levels. Why are legislators lobbying bills that judges wrote? Where's the separation of powers? 2, why are they introducing it? And this bill also has a lot of momentum behind it. So it's got a lot of support legislatively, at least in the Senate. The House, I think, is going to be a tougher battle for them. But right now in the Senate, because Senate President's mommy wrote the bill, and the Senate President fully supports this bill, it's flying through, essentially. So the question is, what is in the bill? So if you were to listen to sponsor testimony, and again, these are family law attorneys who are introducing this bill, their testimony says, this bill is the result of, 20 years of a joint effort, collaborative effort between parents and attorneys and judges and other interest groups to try and reform family courts and make them better. Okay. So it sounds great. It's oh my gosh.
Sugar coated with their sugary bullshit.
Yay. You've been listening and you've been collecting data for 20 years to do the right thing, right? That's what they're leading you to believe. And we're making sure that these custody disputes and domestic relations courts and juvenile courts, this bill applies to juvenile courts too, are child-centered. Great, right? That's all any of us advocates have ever said is we've got to focus on the children, right? Not the power of the courts, not even the parents, really. Focus on children. So they're using all of the buzzwords that we've been using for years. This is family first court reform, emphasizes decreasing parental conflict and helping families and child. It's all about the child. So we've changed terminology that's outdated so that it's not as controversial. And so parents don't fight so much. So we've improved language and terms. And I mean, that's just the gist of their argument, right? What are some of the terms that they're changing that is just earth-shatteringly better? Well, first of all, they're deleting the words parental rights out of custody law. They've deleted it over 150 times. So step number one, we're deleting parental rights from custody law. You know, there is an argument of it can't be about parental rights. It's got to be about the kids. But the idea that we have no parental rights and that courts have ultimate say is scarier than assuming parents have rights. Okay.
I mean, we already struggle with them even upholding the parental rights that we do have. Can you imagine what that's going to be when it's not even noted in there? Like, that's horrifying thought.
Yes. So that's number one. Okay. So if their bill is a 400-page bill, that's one of the reasons it's so long, is because they've literally gone through the Ohio Revised Code and crossed out the words parental rights. They're replacing parental rights with parental responsibilities. So basically, parents don't have rights. You have responsibilities that we, the court, get to dictate and dish out to you. We will decide not just who gets to have the final say. We will decide how are the children going to communicate with you? How often do they get to communicate with you? What can you do in your own home? Where would they go to church? Can they go to church? I mean, they have basically full power to decide what they want to decide, and they get to grant you those responsibilities. So they don't mention in their testimony removing parental rights. Their testimonies are just as telling by what they omit, what they didn't mention. Okay. They did mention changing terminology for the better. So one of the terms they did change was, in Ohio, we have a residential and custodial parent that the court has to choose. They're changing it to designated parent, because that is going to really help families get along better. Because listen, there's no more residential custodial parent. Now it's just designated parent. That way, no parent feels like they have the upper hand or that they've been pushed to the side, because it's just a designated parent.
Here we go.
So that is so much better, but they're really, really, really proud. Really proud about that one.
Time to get your big tall boots on for all that shit we got to wade through now.
Yeah,
that's
right.
just crazy.
I know, but this is huge court reform, Danielle. This is going to really make things better for families, because parents aren't going to fight over who's the designated parent, because it's just the word designated parent. Anyway, I'm sorry, I'm digressing. Another, and even more scary than crossing out parental rights, to me anyway, they actually add the words complete discretion. Courts shall have complete discretion. If you have a case that you've ever tried to appeal, if you go to the appellate court, they'll look at a case and typically they'll uphold orders. It's very uncommon for them to reverse orders. And the reason is because courts do have broad discretion. It's called broad discretion. So the assumption is the court is acting on behalf, using their own judgment, what they do feel is in the best interest of the child. Again, undefined. Okay. But they have broad discretion to do that. This bill increases that discretion explicitly with the language of complete discretion, which means completely unappealable, really, is what that means.
I mean, that is just infuriating, number one. And like, that's disgusting and terrifying. Like, yeah. They already have too much power and authority, and they're trying to give themselves more as if they don't have enough.
That's exactly right. And then, so think about that trickle effect of how that will impact victims of domestic violence. Okay. Their bill does not require any additional training for judges. This bill, it's obviously written by judges for judges. The complete discretion even applies to parents who are in agreement. Think about that for a second. What if two parents agree on a major decision for their child, but they put that agreement before the court, and the court's like, no, actually, I think it's better if this is what happens to the child. And they have complete discretion to overrule agreeing parents. Like, I think people tend to focus on, well, if parents don't agree, someone has to decide. That is arguable. I think there's, a lot to consider there. But let's look at the fact that they're trying to overrule agreeing parents with complete discretion.
And it happens all the time, even now, with the way that laws and everything are set up now. I, as an advocate, like I've really been pushing and encouraging people to share their stories with me. So I've heard hundreds and hundreds of stories, and there are many times where I have, people telling me, parents, we were both on the same page. There was no domestic violence or any kind of concerning issues involved. And the court would go against what they wanted and create conflict.
Right. Again, this is a 400-page bill. There's a lot in there, but it's very concerning. To your point, we're already at the mercy of the courts, okay? But to have it to where it's nearly unappealable, that is not a move in the right direction for anyone, especially fit parents, especially protective parents, especially anyone who loves their kids and actually has their child's best interest at heart. A stranger on the bench. And remember, judges are not child psychologists. They are not developmental specialists. They are attorneys who ran a political campaign and got elected. And yet they not only want to retain their power and continue the status quo of how things are, they want to give themselves even more unappealable power. And that is why it is so important that we stop this bill.
Amen. I'm right there with you. They're already off the chain. Just trying to maneuver through that, their lack of training and their lack of knowledge. They are making decisions based upon their limited knowledge with their limited training, yet that involves very serious domestic violence issues, sex trafficking issues, drug issues, psychological issues. They don't have a clue. And then in addition to that, there's already all too often where even when you have an expert witness come on, they don't pay attention to what they say always. They don't look at the evidence. They don't, there's so many things that they already show complete total disregard for, which at this point, is at the very least unethical sometimes. But, there are rules and procedures and guidelines that they have to follow, albeit it may be worded not the best where there's a lot of interpretation that they can come to for themselves. But man, to take those away now and just give them complete discretion it's not okay. And it's going to put a lot of families in some serious danger.
Oh, for sure. Yeah. And a lot of children, because again, courts get it wrong all the time. And then you think of all of the other court officials, and you have the guardian ad litems, and you have custody evaluators, and you have people who do the psych evaluations. There's so many people involved in this. This bill also allows courts at any time to order unlimited, unending investigations into parents, and even things like parent character. Think about that for a second. A lawyer on a bench is able to order you, if they feel it's necessary, unlimited, unending investigations at your expense. By the way, the bill explicitly says at the parent's expense. And it's not reliant on a hearing. So right now, courts may allow guardian ad litems to do investigations, and they may order, evaluations preparing for trial. This does not require a trial. They can order these unending, unlimited investigations into something as simple as your character at any point. So it doesn't even require a hearing. That is going to bankrupt families more than the courts already are. It's going to drag out proceedings. There is no safeguard for regular people in this bill. This is we know what's best. We need the power to do what we feel is best. And
we are merely peasants.
Yes, absolutely. And I've seen that attitude in the interested parties meetings directly with the judges. I've gotten some very heated conversations with judges in our meetings because of the outrageous things that they say. Some of them really are just jaded because they have seen a lot of bad cases. There are bad cases, okay? 100%. But there's something that happens to them where when they start seeing bad cases, the assumption is then that we're all schmucks, that we're all abusers, that we're all, terrible parents, and you're guilty until they decide you're innocent. Not the evidence, okay, but that their gut. Because remember, the evidentiary standard in civil courts is preponderance of the evidence. What that means is the court kind of looks at what's presented and they kind of go with their gut. It's what do they feel like it's more likely than not? That's all it is. And that's why they get it wrong, because it's so reliant on their gut feeling than actual evidence. And it doesn't require a lot of evidence. Legally, they don't need to have a lot of evidence to make a decision. I'm in the camp of let's see the evidence. Let's start requiring the evidence. Let's help victims collect evidence, but let's rule on facts in reality, not based on feelings. Because as long as they can rule based on their feelings, there is no justice. There's no need for it because they're not even statutorily required to apply it.
I mean, and it completely goes against the entire foundation and basis and reasoning behind having a court of law. I mean, court is supposed to be based upon facts and evidence. The entire family court system is just an absolute joke, and it needs to be completely, totally overhauled.
I agree.
And instead of make, choices and trying to get things passed to fix that, they're going backwards and making it worse.
Absolutely. Absolutely. And I will just tell you from my experience at the State House, if this judge's bill passes, and it's very likely to, because leadership loves the judges, okay? They will not touch any family court reform probably for decades because they'll say, we already addressed it. We got to let this play out for a while before we decide if it's working or not. So this is our time, okay? If we do not stand up and fight this now, our grandchildren are going to still be fighting this. We have to do it.
And as an advocate, this is some dangerous shit. Same as Elizabeth, I'm, fighting up against judges and attorneys and guardian ad litems, and it is already so dangerous what they are doing. This is a we the people thing. We have to start using our voice and coming together and taking action to do the things that we need to do to keep these powers in check and to fight for our rights. This is literally our parental rights that are under attack right now. I mean, if that's not going to wake people up and get people out their blessed chairs, then I don't know what will, but I sure hope we do step up and take action against this because this is not okay. And I agree with you. It will affect families for decades to come.
Yeah. And I think it's important to note that we as people, it really has to be us. And when you're going through it and you have, especially pending litigation, it's really hard to advocate for anything because you're just trying to survive, right? You're a wreck. The people who have the energy aren't doing it because I think there's a stigma attached to family court proceedings. It's it's probably more to the story, right? Two sides to every story. And people who aren't in it just don't care. But then those that are in it are too worn out, too busy,
traumatized.
Yes, there's so many reasons why. But we have to do it, and we have to do it now because gone are the days of relying on, one, our legislators to hear us, and two, relying on organizations to represent us. I'm going to say something that is probably going to make a lot of people mad. But when an advocacy organization gets to the state level where they're getting millions of dollars in state funding, we have got to start asking more questions, and we have got to hold those organizations accountable as well. Because once you get into the big boys club like that, people change, because then their focus is like a detachment from actual real victims on the ground. And I'm not talking about, the organizations that are boots on the ground, like shelters, local shelter. I'm not talking about that. Okay. I'm talking about when you rise to the level of a statewide or federal organization and you're getting millions of dollars in funding, the emphasis then becomes survival of your organization and keeping those dollars coming. It's very much, especially if you're trying to get anything accomplished at the State House, you have to be in that club, right? You have to stay in the club, which means doing favors for each other. This judge's bill, we just talked about all the problems with it. Am I crazy to think that this bill is bad for victims of domestic violence? What do you think?
It's absolutely horrifying for domestic violence victims. Now, while I'm sure they try to word it and phrase it as, oh, well, this is going to help. This is going to help. I mean, we already, again, it's still the same situation to where we do have laws and protection in place right now. They aren't following them.
Right.
They regularly violate due process. They regularly ignore evidence. They are constantly putting children in abusive homes and ignoring the safe parent, and even retaliating against the safe parent. So if that's already happening with what we have in place now, what the hell do we think and what are we to expect that's going to happen with something like this that gives them ultimate power and authority to do whatever the hell they feel like doing?
Right. Okay. So we're in agreement. I just want to make sure I'm not, because I'm going to say something that's good. People are not going to like. One of the main proponent testimony came from Ohio Domestic Violence Network. They have come out in support of this bill. I would like to believe that they don't truly understand what's in the bill or the impact that it will have on victims. I would like to believe that. I honestly don't know what's happening behind the scenes that they would do that, but this is not a victim-friendly bill. I think it will make things a million times worse for victims, honest to God. But they support this bill.
Well, I've found, and I mean, I really hate to say it, but I never in a million years thought I would be in a position to make such a bold statement. But a lot of these organizations, as you say, once they get to the state and the federal level and they're getting all that money, it changes. It does change. And a lot of them are unfortunately become part of the problem. And, when you are an organization and you're getting all of that funding, that also puts you in a position to where, number one, the state and the federal government have some sort of control and say so over what you're doing in and with and for your organization, number one. Number two, they've got all that money to dangle over your head. Oh, well, if you do this, we could do this for you. If you don't do this, then we could just take your funding away. It puts you in a really precarious situation. And I mean, I'm sure it's bound to happen to where the good guys end up going to the dark side for financial gain, same as all of the corrupt players that we have going on here. It's all comes full circle, and it's all the same thing across the board.
Right. And I don't want to make any accusations I can't back up, but it just looks that way, especially if you really read the bill. If you really read the bill, to me, it's so obvious. And anyone I've talked to who's just a regular person gets it. It makes sense. So then why on earth would the highest domestic violence victim advocacy group support this? I don't truly know, but there are some strange things, related to it. So I mentioned Judge McCauley, Senate President McCauley's mom is the one who wrote this judge's bill. ODVN just gave her an award last summer. So there is a club that exists at the state level. We, the people, are not in this club. And we cannot make the mistake of assuming that we, the people, are being properly represented, because all the evidence points in the opposite direction.
Well, and history kind of dictates and shows that as well. So, I mean, it is what it is. And the more that we bury our head in the sand and ignore these things, the more power and control it gives them, and the more they're going to take advantage of that and keep doing what they're doing.
Right. And there's a lot of money. Lobbyists have money. They're being paid to lobby our legislators, right? I can't tell you how many meetings I've been in with legislators where they had to leave because they had a meeting with a lobbyist. Okay. Or they have these lobbyist happy hours or receptions, and all the legislators, not all of them, but a lot of them go and they just walk around for an hour while all the lobbyists get to just yank them aside and whisper in their ear. I mean, these people are paid full time to lobby on behalf of organizations, behalf of industries, on behalf of everyone except for the people. It's wild. It's wild.
The people who? What?
Yeah. Oh, sorry. I'm sorry, citizen. I actually have to leave because I have to go meet with some lobbyists.
Right.
Yeah.
Make it make sense.
Yeah. So I don't want to sound doom and gloom, but this is a very important topic. It's very important that one, we stop this bill. Two, that we make our legislators aware that we know what's going on and that they are there to represent us. And we really have to be loud. In order for us to be louder than a lobbyist, we have to have a giant army. It can't just be me and my small team. And it's a big ask because there's so much trauma and when you're neck deep in litigation, you don't have a lot of time. You're so busy trying to stay alive emotionally, physically, and not go bankrupt financially, keep your job if you have a job. You know what I mean? There's a lot going on. I understand it's a big ask, but we have to, because if we don't, and people who are not in family courts or juvenile courts, people who are not have an active case right now, we've got to get them involved because this impacts them too. When judges are trying to write legislation to delete parental rights, that impacts all parents, not just parents that are going through the courts right now. And if we don't stop this now, it is just going to snowball, especially if this passes, because the judges are going to know we can write whatever we want. We can create bills that give us all the power in the world and no one is going to stop us.
Absolutely. And it's just going to domino effect from there. I mean, that's some dangerous ground we're playing on right there. And for those in the community who do want to do their part and who do want to step up, because I know a lot of people, they would love to do something, but it's, what do I do? Where do I go? How do I get started? Some kind of direction or whatnot. I'd suggest contact, local advocates and local groups that are doing the things that they're talking about. I'm assuming you have socials and such. Like, do you have stuff where you're getting involved and getting in the community and gathering people and such?
Yeah. So because I'm involved in several different causes, I think reaching out directly to me would be the way to do it. I can't help anyone in your personal case. I do get bombarded a lot on social about, I need help. Here's my case. You wouldn't believe the corruption. You wouldn't believe what's going on. I have all the evidence, and I would believe it. Actually, I'm not an attorney, so I can't actually help. But what I am trying to do is raise an army of like-minded citizens who are willing to stand up to this dragon. It really is a dragon.
Well, see, now we can come together with that, because our group does do the things to help individual cases. I mean, we're not attorneys. We can't, fight it for you, but we can teach you your rights and give you the tools and the knowledge that you need to effectively stand up and fight for those rights. So, I mean, like, seriously, just hop on like Facebook or Google, or, find different groups and find different advocates and such that are supporting parental rights and fighting the system and going up against corruption. I'll put, my links down in the description, and then whatever links you want to share, I'll stick those in the description as well. So that way, if anybody in Ohio wants to reach out and join your army, then they can do so effectively and easily. And for those who also need help with, individual cases, feel free to reach out to me. We have meetings every night, Monday through Friday, where we have some of the top advocates nationwide on Zoom calls, to where you can pop on our meeting and we can teach you what we know and help guide you through different processes and teamwork. It takes a village, folks. It really literally just takes a village. I mean, there's so many bad actors and corrupt players. And another thing that I think is imperative that we start doing is the good guys have to start learning about politics and get involved, run for office. We are in this situation because all of these dirtbags have infiltrated our system. Well, it's going to be up to us to infiltrate it back. That's the only way we're ever going to get these people out, is to take it back over.
100%. Absolutely. So there is a web link, which I'll share and you can post, where if you are an Ohioan and you click on that link, it'll take you to a page that describes this judge's bill that I'm talking about. And there's a little widget where you can just enter your name and address, and it'll automatically let you email your legislator right then and there. So if you don't know who your legislator is, this little widget lets you enter your name and your address, and it'll automatically populate a message for you that you can edit to your legislator.
Perfect.
So I'll give you that link. The more people we can get to actually contact legislators, the better. Again, we have to be louder than lobbyists, because if we're not, we will lose. We will lose our parental rights. Courts will have even more power than they have now. It's up to us to stop it. I mean, bottom line.
Absolutely. Time for we the people to step up and take some action and do something. I mean, our parental rights are under attack, for crying out loud. Like, this is not something that you want to toy with. If there's anything that we need to step up and speak up for, it's our parental rights and for our children.
Yep, absolutely.
So do you want to talk about like how you also have a lot going on with ending qualified immunity, which that would be a really big game changer as well. The bill they're trying to pass kind of defeats the purpose of, us trying to work on ending qualified immunity. But if we can, get that bill stopped, get this ending qualified immunity in, then we're going to be in a really good position to make these judges and officials follow the law. I mean, we're not asking for much. Just follow the blessed law, for crying out loud. Like, that's all we want. Just follow the law and do the right thing.
I won't give my whole speech here right now, but if anyone wants to see it, I did give a speech at the State House last week on ending qualified immunity, calling out the courts. So if you go to my Facebook page, it's public. It should be right there. You should be able to see it. And you can watch my 10-minute speech. But the gist is, listen, these courts can do what they want. Two reasons. One, the law is vague. So they do have a lot of power to do what they want, because our laws are just incredibly vague and give them that authority. But they do also stomp on our constitutional rights constantly as well, because there is a lot of case law supporting the fact that we as parents do have fundamental rights. Due process is completely ignored in family courts. Parental rights are also ignored for the most part. They're just trying to codify it in their bill. You know what I mean? A lot of what they're doing in their bill is just making the law to reflect what they really want to do and what they're already kind of doing. But qualified immunity, first of all, it's not law. Okay. Qualified immunity was created in the 60s by the US Supreme Court as a mechanism to protect the government from the people. I mean, that's the bottom line. It came out in Nixon case with whistleblowers. They're just trying to protect the government from citizens suing them. That's what qualified immunity is. It's not a law, though. It's just case law and it's precedent. And courts tend to uphold that. So if you have someone who works for the government in Ohio with our qualified immunity amendment that we're proposing, it would affect everyone who works for the government. So we're talking not just police officers. Everyone gets hung up on the law enforcement part of it, but it's way bigger than law enforcement because it would cover judges, it would cover prosecutors, guardians ad litem who are court appointed, custody evaluators, CPS workers, all those guys. Right now, they're protected by something called qualified immunity. Again, it's not a law. Essentially, the court can look at a case and say, this person was working for the government and they were just doing their job, essentially. So too bad, so sad. So you can't sue them. Qualified immunity would say, listen, if these people are stomping on your constitutional rights, you can sue them.
As well, you should be able to.
I mean, obviously the hope would be then it would dissuade people from stomping on our constitutional rights. Right now, they just don't take it seriously because they don't have to, because they can just fall back on qualified immunity. I would much rather everybody play by the same rules, including people who work for the government, and you have to answer for your bad behavior.
Right. Which, I mean, that's, again, you would think it's common sense, but again, here we are.
Yeah. So ending qualified immunity what we're trying to do is it's a ballot initiative. So we have to collect, I think it's like 400 and something thousand signatures, but we're really aiming for twice that because we fully anticipate that they're going to be rejected. They're going to find reasons to reject signatures, to say we don't have enough. So it's an uphill battle. We're trying really hard, but we have to get a lot of signatures just to get it on the ballot. Okay. So it's taken 2 years to get approval to even take signatures to get it on the ballot. That's because the Attorney General Yost has been fighting against us for 2 years. And by us, I mean the coalition to end qualified immunity. Stupid little things. I'm constantly rejecting the petition to do it. And they ended up having to take it to the US Supreme Court, who ruled in April that Yost's behavior was violating our First Amendment rights.
Oh, there's a big shocker. Not Yost.
That's the whole point of ending qualified immunity, is to hold people accountable for stomping on our constitutional rights. And yet, in the process of trying to get it on the ballot, the United States Supreme Court rules that they were violating our First Amendment rights. Okay.
Case in point.
So anyway, because the U.S. Supreme Court upheld that we have a right to do this and that they're being bad, now we can collect signatures. We have to do it. If we don't get enough signatures, it won't be on the ballot. If you sign the petition, you're not even saying yes for ending qualified immunity. You're not voting on it yet. We're just getting signatures to allow it to be on the ballot for voters to decide.
Right. Give us the choice.
Sure. Right. Yeah. But the powers that be don't want that to happen. Okay. The biggest people who will be impacted by qualified immunity will be the courts. Because if you do want to sue, you can try. So that's basically how it works is, if someone infringes on your right, whether it's law enforcement, whether it's wrongful conviction, whether it's, law enforcement kills your, loved one, whether it's the courts denying you due process, all of that. If you do sue, they will just dismiss it as not applicable because of qualified immunity. So the courts have the power right now today to apply qualified immunity or not. So everything goes to the courts. The courts are the biggest ones to lose if we end qualified immunity because they lose the power to decide who gets it, and they have to consider the cases, and then these cases have to play out. So they're the ones who stand to lose the most. It's not law enforcement, okay? It's not your EMT workers. It's the courts, and the courts are very powerful, and that is why there's such a resistance.
Well, it's got to be even out. We've got to even out that playing field. I mean, these judges having so much unchecked power and authority with no kind of oversight, there's nothing simple that you can do to hold them accountable for any kind of, whether it's breaking the laws or being unethical or, whatever the case may be. it's a lot that you have to go through just to try to hold accountability. But then, it just goes to the other entities that are part of the problem and they help sweep it under the rug. So
Yeah.
we've got to do something about this unchecked power. It's just not okay. And it's destroying so many lives.
Yeah. And I mean, I often refer to the courts as a cartel.
I refer to them as the mafia.
Well, there you go. It's, I mean, the same thing. So the courts ultimately have all the power and final say, but it's all the other minions that do the damage. And then they just mostly rubber stamp it because, again, they don't have a high evidentiary threshold. They have the discretion to do what they want anyway. It is not designed to help families. It is definitely not designed to protect children.
Well, everybody involved, they're all besties.
Right.
And, you got the collusions and the ex parte communications and their false narratives. And, well, this is what we think is happening. So let's make our paperwork reflect that. And it's just all bullshit. And it's really, really scary that they are able to get away with it like they are.
Right. They will try and argue that there's mechanisms to hold them accountable because you can file a judicial complaint. You can file bar complaints. There are things that theoretically you can do. Most of those, though, are dismissed. They will only act on really egregious, obvious cases that they can't legally ease their way out of. And even then, the recourse is usually maybe a 6-month suspension. It's not real accountability. And
that always infuriated me. If you are put into a position of power and you manipulate and you use that powerful position to intentionally and knowingly break the law and cause harm, you should never be allowed to hold a power position ever again.
Yeah. I am an optimist in a lot of ways because I don't think anyone goes into it with that mindset. I think that I do think power just does corrupt over time. And I do think they're blind to their own problems. I don't think they see. There are some evil ones. Obviously, it doesn't apply to all because I do think that there are attorneys and judges and guardians ad litem and evaluators and CPS workers who really just are evil and they really get pleasure out of destroying people or putting people in their place. Definitely those people exist. But I think the vast majority are just complicit because they don't even see it. They don't even see what they're doing because it's almost like they have a savior complex.
Yes. Yeah, I actually, in one of the cases I've been working on, they got a bunch of recordings from court recess, where it was the judge and the attorneys colluding and they were talking about me at one point because I was there, out in the hallway and they're, oh my gosh, oh, she's here. Oh, she's the one that accuses everybody of being corrupt and blah, blah, blah. And oh, she's nuts. And then literally minutes later, they're colluding, making racist comments, doing the things that I'm just so nuts for calling them out for doing. And it's like, are you hearing yourselves?
Right. I do think they're blind to their own ways. Truly, a majority of them for sure are. And they won't hold each other accountable either, because if you think today's judges in Ohio are politicians. They have to run a campaign. They have to get elected. So they're politicians, okay? They're just attorney politicians. That's all it is, honest to God. And especially in family law, because the requirement is like 2 years or something practicing. Like you don't even need like a huge history of experience here. So you just got to win an election. But the problem is, voters don't have all the information to make informed choices, but we also, in rural counties, we don't have a choice. These judges run unopposed. Why? Yeah. Why is that? Why are there not actually fair contested elections? Well, here's how they do it. There'll be a judge that already has the bench, an incumbent judge. They might decide they want to retire or move on to bigger, better things, whatever. And then they'll appoint someone. The governor will appoint someone to fill their spot. So they'll retire during midterm. So that becomes an appointed position. And then they have to run the next election, because the next election cycle you got to run, but they run unopposed. Those judges are installed and they run unopposed because if you challenge as an attorney, if you run for judge and you lose, everybody knows you're not going to be able to practice in that courtroom in front of that judge anymore because you ran against them. So nobody wants to run against a judge because it's career suicide.
Right. Which is, again, illegal. I mean, that's retaliation and illegal, but they do it all the time. And you're hit that right on the head because that's exactly what happened here. The previous judge quit midterm. Karen was appointed and then nobody ran against her. And have a lot of choice words I would love to interject, but I'm going to behave.
I mean, it's career suicide, really, as an attorney to run against a judge and lose.
Yep.
Yeah. So they just kind of wait their turn. They play the politics game until hopefully they get appointed. And magistrates, actually, we always focus on judges, but magistrates are a huge problem too. In fact, especially in family courts, magistrates hear most of the cases. Like the one thing the Supreme Court does track is the number and types of cases that come in, and then whether it was heard by a judge or a magistrate. So we actually have that data. Vast majority of cases actually go before magistrates. Judges do very little, at least in domestic courts, do very little actual work. And most of the labor is done by magistrates. Magistrates are not elected. Magistrates are appointed by the judge. So they hire their friends to be magistrate, and then they just kind of wait in line to hopefully become the next judge. You know what I mean? So it's again, it's all this cartel mafia like buddy system, and they just kind of support each other. And we the people have no true representation and no true accountability. You know, I had an attorney my husband's attorney, I should say. You know, she saw some of the craziness coming from the guardian ad litem in their case, and started out saying, "Oh yeah, we'll put her on the stand. Oh, we'll call this out. This is ridiculous. No, we'll just put her on the stand and we'll question her." Well, the case dragged out for almost 2 years and eventually settled because she said, I'm not going to put that guardian ad litem on the stand. Your case is not, it's terrible, but I have to still practice in that courtroom. So they're not going to challenge each other either because their careers need to continue. Your case might be bad, but you're one case and they have to keep their job, right?
Absolutely.
And then like 6 months later, that same guardian ad litem is now our magistrate.
Yep, that's how it works. The buddy system over there.
Yes. So, I mean, all that to say that the system we have is completely flawed. I don't want to say it's broken because that would imply that it was fixed in the first place. I don't think that's the case. I think family matters do not belong in a court. I think that is the wrong place anyway. When you're talking about child safety, that is criminal. You know what I mean? So these cases that actually involved keeping children safe, that should be held in a proper court with proper due process and taken very serious with very serious penalties. Everything else doesn't belong in a court. It does not belong in a court of law.
Amen. I'm right there with you. I second that.
Yeah, but I don't think we'll see it in our lifetime. We're all together, but that's what needs to happen. So in the meantime,
high hopes, big dreams.
I'm a dreamer. What can I say?
Yeah, it's okay. I'm right there with you. Well, Elizabeth, I am so happy that you came on to share some more information about this. I mean, these are some really scary and serious issues that we got limited time to fight this. Yeah. So we really need for everybody to go to the website. I'll link the website in the description. Make sure you send your legislators, email us, anything, something, tell them this is not okay. You do not want this to go through. And as Elizabeth was saying, it's a nice, quick, easy process, but we got to do something. Regardless, it's time to take action, use your voice, step up and do something.
Yeah, we'll lose it.
Yeah.
We'll lose our rights if we don't stop this. I mean, that I don't mean to sound dramatic, but that is a fact.
Absolutely. I mean, it is what it is. So again, burying our heads in the sand is not going to fix or change anything. And it's just going to destroy us, long term and in the long run. So it's up to us. We the people. We could do it, Ohio.
Yeah.
Okay, well, thank you so much for coming on and sharing this information. And I'd love to have you back on again after, there's some progress and stuff done. Anytime you want to come on, just let me know.
Okay, I will.
Wonderful. Thank you so much, Elizabeth. Have a beautiful day.